Yes, Miss Kelly.
Good morning, my lord, my lady.
I know you've had a bit of trouble getting into the building this morning.
Yes, we have, so apologies for any delay. My lord, I appear on behalf of the appellant, as I did so in the lower court.
Could I just say a couple of things before we start? First of all, this appeal is being live streamed. So for that reason, and indeed other reasons, I think it would be a good idea not to mention the names of anybody in this case, including the local authority. You can name the judge, but not the local authority or the adult members. So we're going to have to agree how we're going to refer to people, because there are two mothers, and the word mother is used interchangeably, I think, in the judgment a few times.
It is.
And so I suggest we call your client the appellant.
Indeed.
And the mother of the subject child, the mother, and the father. Does that make sense for everybody? Secondly, have you had a chance to discuss how you're going to divide your time?
No, my lord, we have not had that opportunity. We've had very brief discussions in terms of what is still opposed, and in terms of the additional application, that is the application to amend the grounds. In light of the email, and hopefully, my lord, the court has received that email from Communicourt. It is not a full report. I accept that. That is not available.
And it's not hasn't been filed in accordance with the rules, but put that to one side for the moment.
I'm grateful for that. I understand in light of that the local authority no longer oppose the application to amend the grounds of appeal, although still oppose the appeal in itself.
Right.
I understand from my learned friend or the mother that the application to amend the grounds is still opposed by the mother.
Okay, right. So going back to the division of time, just so we get the day sorted out, how long do you envisage you will take?
My lord, I anticipate that I will be somewhere in the region of 90 minutes.
Right. Well, that sounds about right. And then you, Miss Stone, will be the rest of the morning, and possibly go into the afternoon. I don't know. Maybe not. And Miss Barry, your case substantially follows the local authorities. Yes. So it sounds, and there'll be time for a reply from Miss Kelly. So it sounds like we're going to be finished in good time by 4:15.
My lord, the only issue I would raise in respect of that is that we do now have an intermediary report that says that the appellant requires the assistance of the intermediary. We've also had a cognitive assessment and a psychological assessment that make further recommendations in terms of how the appellant listens to, obtains and assimilates information. And therefore I would seek that there are regular breaks for Miss Davis.
How often would you like the breaks?
I would suggest, in accordance with the Advocates Gateway, that there is a break of a few minutes, approximately every 45 to 60 minutes.
Okay. Well, let's see how we go, and I'll keep an eye. Obviously, if we keep an eye on the clock, and at a convenient point, either you will remember or I will remember, and we'll take a break. Are you content to deal with it on that basis?
I am, yes,
okay.
My lord. Although I may forget in the moment, as it were.
So may I.
Hopefully,
we'll be reminded.
My assistant behind may remind me.
Is your client in court?
My client does sit behind me.
Yes.
And she is assisted today by a paralegal from my instructing solicitors.
Right. And is the mother in court?
My lord, no, she is not.
Okay.
Albeit she may well be watching
on live stream. Thank you.
Indeed.
Okay. So far as the amendment is the application to amend the grounds, I think what we'd like to do is to we've read the document, De Bene Esse, and so we'd like to consider the substance of the ground, and we'll make a decision about whether or not we allow the amendment in our ultimate judgment. So you can argue the point, the substantive point. Now, when you take your pick as to when you want to argue it.
Indeed, my lord. Okay. I was going to suggest that course of action, as my submissions in respect of an application for permission to amend are going to be the same as my application
Yes.
in the appeal.
Well, now we've read, I think, that all the documents that you collectively asked us to read. Some of us have dipped into the transcripts of the evidence as well. So you can take it that we're pretty familiar with the facts and the background and the issues.
I'm grateful, and on that basis, Lord, I won't therefore give you a background summary. May I just check, because I am aware that the bundles have been filed with the court on differing days due to
Yes.
documents becoming available, that the court has the benefit of the core bundle, which
Yeah.
is an agreed bundle,
Yes?
a supplemental bundle,
Yes.
and then there is a further supplemental bundle.
Yes.
And in that bundle there is two chronologies, one which outlines the injuries and marks that have been found on J whilst at school, both before and after the relevant time period, and another chronology which sets out what each of the parties says happened on that relevant time period from the 18th to the 20th of January, and that information is contained, as I understand, in the additional supplemental bundle that was filed late to enable it to have all of the paginations once the bundles were agreed to assist the court.
Did you have a direction allowing you to file additional bundles?
No, my lord, we did not. We had a direction, and it is identified in that chronology that when the application for to amend the grounds of appeal, the direction there was to file all the documents that were
That's
relied
right.
upon, and that was a broad direction.
Okay.
And
All right. Well,
instructing solicitor has made use of it.
let's get on then.
I'm grateful. Thank you, my lord. As I indicated earlier, I appear on behalf of the appellant, as I did in the lower court. Leading counsel, Miss Stone, appears on behalf of the local authority, as she did in the lower court. The mother today is represented by Miss Bari, who I understand has previously represented the mother on a couple of occasions, but was not
at the hearing.
Not counsel at the fact-finding hearing. My lord, just before I start, I just want to check that you've also had the documents that were filed on behalf of the mother. They came in very late yesterday
Yes.
morning at 9:30.
Yes.
There was within those documents a note, an explanatory note as to the delay. I raise that only that I note in the email correspondence between the court and instructing solicitors, there was an indication that the court might require to hear from the mother's advocate.
Yeah, well, I asked for a written explanation of the reasons for the late filing. I've seen that, and if I have anything more to say about that, or if we do, we'll ask Ms. Barry about that when we get to her.
I'm grateful. In that case, my lord, I will go straight to my application to amend the grounds, reintroducing what I say is ground one, that it is a procedural irregularity and unfairness in respect of the mother, in respect of the appellant, in that the appellant had unknown cognitive difficulties, and on that basis, given that there were no ground rules hearing, there was no provision of any intervention for the appellant, that the hearing was not in that basis fair to her. And the reason that I say that is that the judge, Her Honour Judge Nisa, from the evidence that the appellant gave, formed a view of the appellant, and that was a very negative view. And I say that that view arose out of the way and the manner in which the appellant gave her evidence, and the manner in which she answered those questions. I say in relation to the law that is outlined in my skeleton argument, and it's at a 38 to 43 for the benefit of the court. I do rely on that law. I don't intend to repeat it unless the court wishes me to do so. However, to say simply that in respect of all of the grounds, the appellant is perfectly aware, and I accept that Her Honour Judge Nisa had a very wide discretion, and that there are Court of Appeal decisions where any applicant is referenced as having somewhat of an uphill task, and my lord, I do take that on board. I will address the court in respect of the permission, in that it is still opposed by the mother. And what I say in respect of that, and it's outlined in the Skellington argument, that as a trial advocate, some concerns were not raised by me, but I had some concerns in respect of the mother's evidence as it progressed. I would go no further to say that it was a concern. It was more of a niggly unease, as opposed to a firm view that there was a cognitive issue. And certainly I would say there wasn't enough at that point to raise red flags that would require me to ask for the proceedings to be stopped and for a cognitive assessment to be undertaken. It wasn't clear to me, and even on reflection of the transcript of the intervenor's evidence, I'm still not entirely convinced it comes across whether mother had cognitive difficulties, difficulty understanding the questions, and whether that was down to giving evidence in a stressful situation. And my lord, you will note from the transcript of the intervenor's evidence that in particular with her evidence, there were significant issues with the technology, with being able to hear questions. Miss Stone, for the local authority, endeavoured to ensure that the intervenor could hear all questions that were put to her, but there was definite difficulty with technology in respect of the questioning.
So just help me with how it worked. Where was everybody located?
We were all remote. The intervenor was attended remotely from my instructing solicitor's office, but she was alone in the room. So she didn't have the assistance of a paralegal or a solicitor.
So she was alone?
She was alone in my solicitor's office.
Where was your solicitor? Not there?
No, in another room. She wasn't in the building on her own, but she was certainly in the room when she gave evidence on her own. And my lord, that is evident from the transcript, because there are...
And where were you?
I was at home.
And where was Miss Stone? Was at another location?
Yes, Miss Stone was at another location.
And the judge was another location?
Judge was at another location. I cannot recall off the top of my head if the judge was at home on that occasion or sitting in court, but certainly the advocates for the parents, as my understanding is, were at home and had some difficulty with technology. And my lord, you will see from the transcript, I don't need to refer you to it, it is there, that Miss Knight, who sits behind me today, was required to go in and assist the intervenor to re-establish her connection on a couple of occasions. So I say it wasn't a clear-cut case that there was cognitive difficulties during the course of the intervenor's evidence. And of course, in these proceedings, she was an intervenor, so there wasn't regular input with her in terms of assessments, in terms of talking to the social worker. And you will have seen from the judgment, my lord, that the relevant social worker in the matter of this case had not met or even spoken to Miss Davis. And so her instructions were in respect of what she said happened and responding to the evidence of the other party.
So the local authority at that stage weren't involved with your client?
My understanding is that there was child in need, child protection, as a result of the Section 47 inquiries, but it is right that no proceedings were brought at that time.
But Jay had been identified as a child in need. Is that right?
result, it came after.
Following the Section 47.
It came, yes. The Section 47 in respect of the injuries came first.
Yeah, but at the time of the hearing, your client had a social worker involved in her life.
Yes, that is right.
While I'm on this, there's something I just wanted to ask you before we started. Forgive me. What's the current position about Jay? Are there proceedings ongoing?
Yes, my lord, there are proceedings.
And where is Jay at the moment?
At home with his mother.
Under any order?
Uh,
Interim order? Care or supervision?
I believe, and Miss Stone can correct me if I'm wrong,
Supervision order. When are those proceedings coming to the final hearing?
There is, I understand, an IRH in December. My instructions, and of course I haven't been involved in that case for some time. The last hearing was a little while ago. But on my instructions, and Miss Stone will correct me if I am wrong, and obviously I won't go into too much detail because of course the mother and father in these proceedings are not party to those.
Yeah.
That it appears to be going well, and on my instructions may well conclude. That is the only information that I have. Miss Stone, I can see looking towards you, my lord. But we have.
I was wondering if Miss Stone could confirm that in simple terms, one way or the other.
I can't confirm it, my lord. All I know is the IRH is the 20th of December. Parenting assessment due to be filed at the end of November, 29th of November. I can't comment on the.
And you won't be able to comment by getting further instructions at this stage.
I could get some further instructions.
Yes. Well, it will be helpful for this court to know, if possible, what the likely outcome of those proceedings is. If you can tell us. Thank you.
Are they also in Guildford County Court?
As far as I'm aware,
And
yes.
is Judge Nisa seized of those as well?
Can I just have a moment?
Yeah, I may be able to assist there, my lady. Yes, Judge Anissa is seized of those proceedings. An application was made at the outset for recusal, but on the basis that the findings hadn't at that point been appealed and they stood, that was refused. So yes, Judge Nisa is still seized of those proceedings.
Yes. Sorry, I interrupted you. You were putting forward your arguments on the amended ground one.
Yes, I'm grateful. Thank you, my lord. So further concerns. The intervenor had no further part in these proceedings once the fact-finding hearing came to an end, and she was discharged from those proceedings. Therefore, it wasn't possible at that point to identify that there may be a need for further assessment of the mother's cognitive abilities or indeed a psychological assessment at that time. Proceedings in respect of Jay were not brought until much later than March the 1st, when judgment was handed down. And it was only in the course of those proceedings and exploring with the intervenor the evidence and the findings that it became more apparent that there may be a cognitive issue and an issue with understanding. And therefore the intervenor underwent a cognitive assessment by Dr. Taylor.
Yeah. Part
of the application today is for permission to adduce that evidence together with the psychological report of Dr. Joslin. It is provided on a heavily redacted form, in that there are only 2 paragraphs that are unredacted, one in each one. Mm-hmm. The paragraph in respect of Dr. Taylor's report suggests that the mother may have some low-level cognitive functioning, but there are no special measures that have been recommended. Ms. Stone very helpfully pointed out to me outside of court this morning that she wasn't aware that the cognitive assessment was to be redacted. She is, of course, I understand, involved in the other proceedings, so had access to that. And one of the questions that Dr. Taylor was asked was whether or not the mother required an intermediary. I cannot see that has been specifically answered, save to say that she doesn't need, in his view, any particular intervention, but there may be ways in which she could be assisted. That led on to the intervenor having a psychological assessment by Dr. Joslin, and that report came in again much later. and it's in that report, there is one paragraph, my lord, my lady, that you may have seen, where she suggests that an intermediary may be necessary. And it was on seeing that report that it was considered to be prudent and in fairness to all parties and mindful of court time to alert the court and parties to the fact that an intermediary assessment was going to take place, and that took place, as I understand it, on the 17th of November, so only last week, and that in the event that indicated that the intervener required the assistance of an intermediary, then permission would be sought to amend the grounds of appeal. And accordingly, my instructing solicitor made that application in any event.
Yes.
And my lord, it was initially opposed by the local authority on the basis that it was only a may need an intermediary. And there was some suggestion that that information, with a sort of diligent forethought, and could have brought it to the attention of the judge, and a cognitive assessment could have been undertaken during these proceedings, during the fact-finding hearing. And my submission for the reasons that I've given above is that would not have been something that we were able to do at that time, and that this information was not available at the fact-finding hearing and couldn't reasonably have been made available.
And we now have a letter from Community Court.
And we do, my lord. We have a letter. As I said at the outset, I accept that it's not a report and it doesn't set out any full recommendations. That report won't be available for a week. Community Court were asked to provide a very brief bullet point summary, which they have done to assist the court today, and that has been circulated to the parties. And it's on that basis that I say that the intervener, the appellant rather, is entitled to be considered as a vulnerable witness, and accordingly she should have been afforded the ability to have had provisions put in place for a vulnerable witness, which would have included consideration of how questions were put to the appellant, how they were formulated, and consideration to her responses would have been able to have been taken. And it's that I say is really relevant for the purposes of this appeal. In terms of the assessments by Dr. Taylor and Dr. Joslin, Ms. Stone rightly points out to me today that she has seen the unredacted versions, and they do not make reference to the appellant having said that she didn't understand the fact-finding hearing. And of course, I have to accept that. That is, that they're not in those reports. However, those were not specific to court proceedings, and of course we now are awaiting an intermediary report which will be far more focused towards the court proceedings and her participation, and it is unknown at this time whether there are any comments made in terms of understanding of the fact-finding and the fairness to her in that report.
So there's going to be is there going to be a ground rules hearing in the proceedings ongoing regarding Jay, or does that depend on what happens at the IRH?
I anticipate that at the IRH an application will be made for a ground rules hearing. I don't anticipate that it's going to be sought that there's a separate hearing. There are fairly standard recommendations and interventions that are taken in accordance with the Advocates Gateway, and if there are any further recommendations made by Community Court, then they can be incorporated into that. But it will, of course, put the court on notice that the appellant has those cognitive difficulties and those difficulties with assimilating both written and verbal information. So in terms of the judge's view of the appellant, which I say arises out of the appellant's evidence, what the judge says at paragraph 33, and it's at A29 of the bundle, what Her Honour Judge Nisa says there is, the intervener has lied, and it is not in my view because she is embarrassed. She has far more to hide and a lot to lose in that regard. Even in her evidence...
So which paragraph are you reading from now?
Paragraph 33 of A29.
Yes. This is on the drug-taking issue.
Yes, but I'm referring to it on this occasion as a generalisation of the judge's approach to the appellant's evidence. And she says that she, at A30 then, my lord, the judge recounts her dissatisfaction with the mother's, I'm sorry, my lord, I've lost my moment. So yes, I'm back at paragraph 33 of A29 where the intervener is said to have lied, and that is in the judge's view not because she's embarrassed, but because she has far more to hide and a lot to lose in that regard. And the judge says even in her evidence, she did not seem to give it the seriousness that she ought to have done. And I say that is a reflection of the intervener's understanding of the proceedings and is evidenced by Her Honour Judge Nisa there. The judge goes on to say she was still in partial denial, but by her attitude, she was trying to state that it was something wrong with the results. The testing was not right, and the result would have been different if she had not used hair dye, etc. And then she says, I was not impressed by the intervener's evidence. Of course, we know that the judge has amended her findings in respect of part of the appellant's drug use, where she says she accepts that the quantity of the hair strand test was not something that the intervener had tampered with. There was only 7 months that could be tested, 9 months were provided, so the full 9 months were given, and the judge accepted that. In terms of the injury to the face, the slap mark, as it has been referred to by all, paragraph 36 to 37 of her judgment at A30, the judge recounts her dissatisfaction with the mother's account of what she did when she found those injuries. I'm not going to go through those specifically, but at paragraph 38, the judge records that the appellant's evidence generally, I would say she was very deflective, unable to answer the questions in a way that lost the actual question. I would say that her answers were calculating, and I think she certainly started the campaign to point the finger at this mother in these proceedings to deflect away from herself. And what I say, my lord, is that's a clear indication of the view that the judge took as a direct result of the evidence and the way it was given by the appellant. And what I say that now the appellant's evidence must be looked at in light of the intermediary recommendations, small as they are, and potentially in light of the assessment that is forthcoming. And I say that the question that the court needs to consider is, would the judge have formed that same view and reached those conclusions had she had the benefit of an intermediary report? Had she
You've gone to 38. Are you going back to 36 and 37?
A30, yes. Paragraph 38, yes.
Yes. 36. If we trace it through at 37, she goes through the appellant's
Yes.
account of what happened to Jay that morning.
Yes, she does.
And she's asked the question why she didn't text the mother saying, can you tell me what happened to the face?
Yes.
So that is the fact that she didn't ask that question, didn't text the mother, is a point that she takes against your client.
Yes.
Judge. And then she bumps into the friend and asks the friend.
Yes, and it would appear, my lord, from the judgment that the judge doesn't entirely accept that there may have been a friend even present. I'm not certain how the judge.
Your
reached
client's
that.
account was the friend had said it looks like a slap. You better inform social services. That was what your client said. The friend
Yes,
had said,
indeed.
and the judge then relies, it seems to me, for my part, quite heavily on the delay of 40 minutes
From school, indeed.
before she did that. I'm taking this quite shortly. If the mother was so concerned with somebody else, she would have informed the school immediately. Mother there, in both cases, that's the appellant, isn't it, of course? I would say her actions are surprising. She didn't seek some guidance from the school, went home and thought about it. Is it part of your case? And does nothing about it for what she calls a considerable period of time. Is it part of your case that in evaluating your client's behaviour that morning, it is, isn't it? This is your case, really. In evaluating your client's behaviour that morning, the judge did not take into account what we now know about your client's difficulties because she didn't have that information available.
Indeed.
And do you say that taints the judge's findings on this issue?
Well, Lord, as I was going to go on to say that based on that, had she known that information, had that been available, had there been some measures put in place that would have assisted the appellant to give her best evidence, that it would be likely that the judge would not have reached those conclusions.
Well, there are 2 points really. First of all, there's a question of giving the evidence, the quality of the way in which the assessment of the evidence, but also what your client did that morning. Is that also part of your case?
It is. I was going to address you in more detail in respect of that.
In your own time.
In submissions when we get there. I'm happy to.
But it is relevant.
To do that now.
It seems to me it's relevant.
It is relevant.
If your client has some learning difficulties of whatever sort,
it is
borderline, then it's relevant to the interpretation of her behaviour that morning.
It is indeed very relevant to the interpretation of her behaviour and what she considers to be the correct course of action. And the mother has been quite consistent, I would say, in the accounts that she has given, firstly, and off the top of my head, because I'm not quite there yet on my paperwork, I believe it's at A2, she says that she was shocked and she didn't know what to do. She gives her first account that she saw a friend, another parent at the school, and asked her what she thought of the marks on Jay's face. That was repeated in her statements. It was also repeated in her oral evidence. And what I say in respect of that, given the appellant's difficulties, certainly what is said by the intermediary in respect of her difficulty with memory, it would be unlikely that this intervenor, this appellant, would have been able to have remembered exactly what she said on each occasion to each person, and she's been consistent in that element of her account.
Perhaps you can't go that far, but you can say it's open to question, can you? To what, in considering whether she would have remembered.
Yes.
What the court would take into account what they know about her.
I, of course, my lord, am stretching the point as far as I can in the appellant's favour, but yes, I would accept that that is something I would say that is open to the court to have found.
Ms. Kelly, can I just, my reading of paragraphs 37 and 38 are that the judge really based her conclusion on 3 facts, and let's just get them out there. 1 was the 40-minute delay.
Yes.
And 2 was who was notified, not the school, but the social services, I think, were notified. And 3 we haven't touched on yet, but it's the point that comes out of 38, the inherent unlikelihood of all these injuries having been inflicted by someone else whose own child hadn't got any bruises or injuries of note or concern. So it seemed to me that it was the conflation of those 3 things together, and they're objective facts, you might say, that the judge is entitled to take account of. that led into her adverse conclusion to your client?
Yes, I would accept that at the beginning of paragraph 38 certainly feeds into the judge's conclusion, but I would say that without points 1 and 2, even in light of point 3, had she known, had anybody known about the cognitive difficulties and indeed the memory issues, then that she would still, I say, likely not have reached those same conclusions, or I would say she shouldn't have reached the conclusions that she did.
Or she might not have done.
Yes.
Can you go further than that? She might have done, but she not having this. This was your case. This was a crucial part of the jigsaw piece of information in interpreting your client's evidence.
Yes, and my lord, I say that the jigsaw wasn't complete, as it were. That the judge had only parts, and in my final submissions, when I hope to draw it all together, I will be saying that Her Honour Judge Nisa hadn't looked properly at the broad canvas when she was reaching her conclusions, and that she focused in my submission, particularly in respect of the appellant, in terms of the lies in respect of the ketamine use in February. There is, I say, my lord, quite heavy reliance placed on that. And whilst it's right that in her judgment, Her Honour Judge Nisa does remind herself of the Lucas direction, and I would say in my submission applies that liberally to the mother's evidence in this case. It certainly doesn't, on my reading of Her Honour's judgment, appear that Her Honour has applied that Lucas direction correctly to the intervenor. She seems to have founded that having lied about the ketamine use is my submission that the judge has placed too much reliance on that, and has found that she's lied about other things, which I say the evidence doesn't support. But I will address you in more detail in respect of those. It is said by Miss Stone on behalf of the local authority in her Skellington argument that the mother was able to answer questions, and I don't shy away from that. I accept that. The mother did answer questions. The appellant did answer questions, and yes, she was able to say that I'm slow at reading and that I have dyslexia. And Miss Stone goes on to say that I intervened on occasions on reflection of the transcript of the appellant's evidence on more than 2 or 3 occasions, asking for the intervenor to be referred to documents because it seemed to me that there was some confusion at that time. And what I say in respect of that, and I know that the local authority don't oppose the application to amend, but I'm going to respond to that because it is supported by the mother who does, is that intervention by counsel to guide to a paragraph, to seek that guidance to a paragraph is provided, is not a satisfactory substitute for proper consideration, evaluation and measures for a vulnerable client giving their evidence. And I say that it doesn't negate away from the fact that the appellant required an intermediary. In terms of evidencing issues with the mother, with the appellant's participation, and I don't want to labour these points, but at C203, when answering questions from the local authority, as already said.
Let's just get it. C203. Yes.
When answering questions from the local authority, as I have already alluded to in my earlier submission, that the appellant says that she is a slow reader, and that's at the quarter way down the page. Yes, sorry, I'm a bit slow at reading. And then the the appellant is asked to read an account from police, and she's asked if she recalls what she said. And bear with me, my lord, I appear to have lost my reference for that. Yes, it's a little bit further down. She's been asked if she recalls what's been said in the report and what the appellant responds to. And the particular paragraph she was being referred to is her initial account of the injuries and how she saw them. But what the appellant responds to is there's actually been along the way a few things twisted, and I'd say it was social services. And then she's asked, what do you say was twisted? And she says, as in, I said all the way through, I knew where Josh was.
Jay.
Yes, thank you, my lord. I knew where Jay was. I knew what flat he was in. I just couldn't remember what number, the door. And I said that all the way through. And in this, they've just keep writing down, she didn't know where her son was. And it's clear that the question from Miss Stone was in respect of the injuries, and yet the appellant had missed that in the question, and that may be part of the judge's reasoning that she was deflective or answering questions without answering the question, and I say that that is a relevant issue. At C204, and I'm not going to go through all of them, it's just a handful that I have picked out. At C204, the appellant is asked how long, in the middle of the page for the court's benefit, how long had she been friends with the mother in the proceedings? And the appellant struggles to know and tries to date that by when her elder son started a particular school. But the mother struggles with the date of that as well. At C207, the appellant is asked if she knows what an abrasion is, and she replies, is that a bruise? In answers to questions on behalf of the mother, and it may be helpful to look at it at C248, it's in respect of marks that have been seen to Jay. And it's a third of the way down. For context, I will read the preceding sentences. It says that in C40, in your statement to the court, you said you did not see any marks to the face. The answer is I didn't, apart from the red face. But you see it's different to what you said to the doctor. And the answer is, well, so the doctor was on a Tuesday and Jay got dropped back to me on a Sunday. The question is right, and then we've got a different version when you do your statement to the court in September of last year. And then the answer is a question where? And it's what you're looking at C40. And the answer is, what do you mean? I've got a different statement. I said a different version. Okay, let me look at it slightly differently. And again, I say that that's indicative of the mother having difficulty following the proceedings and following the questioning, particularly on reflection with the transcript.
Well, it goes on. Top of 249. This is the mother's advocate, is it?
It is, yes, my lord.
She says, we'll come back to that tomorrow.
Yes.
And your client says, you're trying to confuse me and it's not working.
That's right, yes, my lord. And the response is, I'm not trying to confuse you, but clearly the appellant felt, I would say on my submission, some degree of discomfort at that point, at the way the questions were coming towards her, and is demonstrating a lack of clarity and understanding. And I say that had we had the benefit of the intermediary report or even the recommendations that the court has now, that there would have been some thought given to the formulation of the questions so that it was easier for the appellant to follow the train. As I said, the appellant was in a room on her own with an electronic bundle and later, I believe, a paper bundle, trying to get to the relevant pages.
Well, your client at the bottom of that page says that apart from the red face, that's all I saw.
Indeed.
Is that is there? Do these points that you're making undermine the reliability of that statement?
No, I don't think they do, my lord. No, I don't. I do want to address the court in terms of the comments made by Her Honour Judge Lisa shortly after that. And again, I say that is indicative of the judge having, I say, reached a premature view of the mother. And what she says here, it's right at the end, C249. Right, okay, thank you. Can we sort of try and finalise this? The sooner the better. We are running out of time already, so perhaps we could try, and if there is any way of making it quicker, please. And I say that that's an indication from the judge to rush things along, and it's in stark contrast to the manner in which the judge treated the mother in the proceedings when she gave her evidence. And of course, my lord, if the courts have the opportunity, and I don't wish to go through it, I'm not appealing on behalf of the mother, her evidence, the court will see that's very disjointed, very confused. Many of the questions are answered with, oh, I don't know, I can't remember, and are contradictory. And I'll come on to the contradictions later in terms of the broad canvas. But what the judge says to the mother, and it's at C156 that I've picked out in particular.
Between the two hole punches.
Yes, and the mother, having given some of her evidence, has been distressed. I am above saying that I will try and not repeat questions already asked, but there's going to be some questions. And the judge's response is, well, okay, in that case, we're going to take a break. Now, mother, if you can join us at 2 o'clock, have something to eat, just calm down. You are doing very well. It's very important that you tell me the truth, and it's very important that you give your evidence. Something has been said that is not picked up for the purposes of the transcript, and the judge responds, I appreciate that, I appreciate that. There's a lot that's been asked of you, but I've got to get to the bottom of this. And then a bit further down, I think it's really important that you get the chance to give your evidence with which you are doing. So stay calm, have something to eat, have some lunch. And I say, my lord, that there is a stark contrast between the judge's view and the way she approached the evidence of the appellant and the way she approached the evidence of the mother. Moving on to C279, and this is when the appellant is answering questions, again on behalf of the mother.
Sorry, repeat page reference again.
C279.
Yep.
So there is a, bear with me one moment. Yes, so it starts at the top when it's been suggested to the appellant that she'd tried to blame the school. These were for previous marks that were seen on Jay's face some time earlier. And it suggested that she wanted to say these were caused at school. And so the answer is, sorry, which part are we talking about now? The question is the same marks. to the appellant. And the appellant says, no, we were talking about the blue bruise. Now then we're talking about where he got a toy chucked in his face. So that's two different injuries. So which one? And then she asks, can you tell me which one you're looking at? And then the judge intervenes in the middle,
Yes.
And goes through it. And I say that's another clear indication of the mother's, I say now, confusion.
The appellant's
Yes, yes, the appellant's confusion and difficulty with giving her evidence. The appellant is asked at 283, and I am coming soon to the end of these indications, but at 283, what is said there is she's asked, I would say that an ambiguous question. It's just so we are clear, you know about the mother's past, do you not? And the answer is no, apparently not. And then the question is, well, you know about, and the rest of the sentence isn't there. And the appellant replies, she told me a story. Whether it was true or not, I don't know. The question is, she carries a story that something in prison to support police prosecution. She told me she was sleeping with a man and her husband came in and caught her. And then she's told that is not the question that I asked. Well, in fairness to the appellant, the question was fairly broad. That's the answer that was given. And then it suggested that this is not the question that was asked and that it's a ploy on behalf of the appellant to deflect away from herself. And it suggested that this is, if she doesn't like the questions, then this is what she does. And I say, well, that's in itself is something that the judge adopted in her judgment, in that she was deflective and sought to blame the mother in these proceedings. And I say it's another clear example of the appellant not understanding what was being asked to her. If we move on, the appellant is asked about a video that was referred to in oral evidence that was sent to the appellant by a third party, which was alleged to evidence the mother and the father in the father's van during the proceedings. And it's clear that the appellant, I say, got lost in this line of questioning at C290. When she's asked about the video, and it's when it is explained to her what the video is. The question starts off with a large paragraph. I was starting with a question that related to matters that were dealt with this morning, and I'm asking you these questions just to let you know, because I will be suggesting that you have lied throughout these proceedings, you have lied to the court and you continue to lie. The question relates to the video that you say you have of the mother that we sent you.
Which I haven't found where you're reading from. So.
Oh, my apologies, my lord.
289, I was the wrong page.
289
Thank you.
over to...
Got it, thank you.
It's the large paragraph.
I'm there.
Penultimate Q.
Thank you.
And then the question finally comes, now do you accept that you have lied to the court in relation to where that video came? And the answer is, I never said anything about a video. I even went on my old phone to double check, and there isn't a video. And what the appellant is referring to is that video that I've just alluded to, that is an alleged video sent to the appellant during the course of the proceedings of the mother and father together in the father's van, when their evidence was that they weren't together and they hadn't seen each other. So the appellant is clearly thinking of that video. No, my lord, I'm so sorry. My submission in that respect is incorrect, and I'm going to start again. There was reference in the police disclosure to a video that was taken by the mother of Jay at the relevant weekend and was sent to the appellant, who then provided it to the police. That video was never obtained. It was sought, it was asked for. It didn't form part of the police disclosure. That had been put to the mother earlier, that there was a video, that she hadn't disclosed it, and it would have showed marks to Jay's face. So I say here, when the appellant answers the question on behalf of the mother, she is referring to the video that the police record as having received. There was a recording that the mother sent, the appellant sent, but a video was never received from the police, and the appellant didn't recall sending it. However, the question is in respect of the video, the alleged video of the mother and father in a van. And I say again that that is indicative of the mother, not the appellant, not understanding the questions that have been put to her. And at C290, when it's explained, she says, "Oh, that video. No, the video of the mother walking. I don't know who actually took that video." And my final example of the mother's difficulty with the questions and her evidence is at C297. And again, it's questions on behalf of the mother. It starts at the top. If I read the question from the previous page, might give the context. There's a suggestion to the appellant that Jay had a bad night. He came back to you. The appellant says it was a bad evening, but he went to sleep and stayed asleep till the morning. And then it's suggested that when it was that bad, you did something, did you not? Clarification is sought, and the question is put again, that during that bad evening, as you have called it, you'd injured him, you'd had enough. The answer is no, that didn't happen. And then the question here comes, he came back to you, and again I say it's a long question. He came back to you, I suggest, overtired and a bit emotional. He started crying, you could not control him. And I'm not suggesting you did anything deliberate to hurt him, but that night got out of control and you injured him. And the response to that is, no, Jay wasn't out of control that night. And again, the appellant rather, has misinterpreted the question and provided her answer to what she thought that she had been asked. And I say that all of those difficulties with the mother's evidence has given rise to the judge's view that the mother, the appellant, was deflective in her responses, so that the questions were lost, and that she sought to put the blame, as it were, on the other parents. And so finally, in respect of that, my final submission, as I have said earlier, is that had the parties been aware, measures would have been put in place, consideration to her needs would have been given, questions properly and appropriately framed, and likely in those circumstances, I say, or at least likely there would have been a different outcome. And I rely, as I said at the outset, in the law in respect of my skeleton argument, in particular Re-M and Re-N, and the comments of Lady Justice King set out in the skeleton argument at A42 to 43. And I submit, in the light of the above, there was a fundamental breach of the appellant's Article 6 rights, and the decisions and findings that are made by Her Honour Judge Nisa are unjust because of a serious procedural irregularity. And on that basis, I seek both permission to amend the ground of appeal in respect of ground 1, and in the event that permission is granted, for those same reasons, I say that the appeal should succeed.
Thank you. Well, now, you've been going for just over an hour, actually just under an hour, but that would seem like a good point for a break. Should we say 7 minutes? Would that be about right? You won't be able to leave the building, but you might be able to step outside into the corridor. Would that be? Would that meet the requirements here?
Yes, my lord.
Thank you very much.
Thank you.
Bye.
Moving on. Thank you. So we can step outside. Sure.
Not yet, I'm fine. Cause I had okay. Yeah, probably in the afternoon now, but I'm fine.
I mean, you can go any time as soon as I'm here.
Yeah. No, I'm fine. Yeah. Yeah.
You may find you might have, they might not know where to come in, so you might have to go to the door
Let them know
so you can
when they will come back.
yeah. They should just knock and close the door themselves, really. If they don't come back in about 5 minutes, just go and call them in. Yeah.
Yeah.
Rise.
All right?
Yes, my lord. Thank you.
Yes. So where do we go now?
My lord, I'm now going to continue with the ground that the court has already provided permission
Yeah.
for the appeal to be brought on, and that is ground 2, that the court departed from the view of Dr. Goddard, in her opinion, in respect of the injuries to JD, specifically.
Yeah, just a moment. Yes. Thank you.
Specifically that injuries 1 and 2 were inflicted by the appellant after Jay returned to her care on the 19th of January and probably in the morning of the 20th of January before he arrived at school. That injuries 1 and 2 are likely to have been caused in the same incident when the appellant slapped Jay. And what I say about that is that Dr. Goddard at C10, what she says there is at the bottom, it's at the very last answer to a question when she's asked about the mark on the ears, the court to the left ear in particular being an area of concern. So is that mark problematic in terms of causation? And the answer that Dr. Goddard gives it isn't an area. It isn't the area where bruises are seen more commonly in abused children and in non-abused children. And the mechanism might be sort of holding a child by the ear or pinching the ear. So it is of a concern. She goes on and repeats that view where she says, it's at C11, it's 1, 2, 3, the 4th paragraph with an A next to it, just underneath the top hole punch. So I think the red mark, which is maybe a bruise to the outer, the canal part of the ear, for that to be inflicted by an adult or by someone holding the ear tightly or pinching the ear. And I accept, as set out in Miss Stone's skeleton argument, that Dr. Goddard does accept the possibility that it could be a different mechanism. In my submission, in that respect, in accepting that it's possible, anything is possible. It's what is more likely, I say, that carries more weight.
Didn't the judge make this finding on the basis of all the evidence, as she was obliged to do? Dr. Goddard's evidence was important, but only part of the evidence.
Indeed, my lord, and I accept that, and I do accept that the judge had a wide discretion, and that she's not bound to follow the expert's evidence. But given Dr. Goddard's view in respect of that, and that is something that was also recorded in respect of Dr. Waddy at A8, where it's recorded that he records the marks to the ears as 2 separate marks, so the slap mark and the mark to the ear as 2 separate incidents, and the reference for that is at A8. Dr. Goddard was asked was asked questions whether or not, if the mark had been there before, that particular red mark, would she be so concerned? And at C49, what she says is that the mark had been there before, she would be happy for the red mark being dismissed. And what I say in respect of that is that the appellant says, and it's at C208, that the red mark on one side of Jay's ear had been there previously and was still there. It was suggested to the appellant on behalf of the local authority at C210 that the appellant hadn't mentioned that mark to Dr. Wadey. The appellant says she did. She's quite clear in her evidence that she did, but that he didn't accept it, and he said he knew what a bruise was. I say that the appellant's position is supported by the entry log at A13, which is an account that's taken recently after the injuries had been found, where the mother is recorded, the appellant is recorded to say that the mark on top of the ear had always been there. So I say that in light of the appellant's evidence, the evidence before the court that's recorded by the two experts, and also the recording that the appellant had reported it as being there previously at A13, that there is no good basis for the judge to have departed from that and found that it was an injury that was caused by the appellant. I would say, my lord, that on the evidence it would have been open to a reasonable judge to have concluded that that red mark that is attributed to the appellant was one that had been there before. It's certainly referred to in the papers as the school having seen a red mark on the child's ear previously. And as I said, the appellant's evidence was...
Well, are you saying the finding the judge made wasn't open to her on the evidence? Or that it was not, how do you put it?
I frame it in both ways. I say on the evidence, it doesn't support the finding, and on that basis, it wasn't open for the learned judge to have made that finding. And if we then turn to the 4 parallel lines, which is referred to as the slap, it was suggested to Dr. Goddard that Jay had had a similar injury before, C42 of 2 parallel lines, one thicker than another, noted at school. And Dr. Goddard at C43 differentiates between those marks, which disappeared very quickly, saying there can be marks of the face, but going back to these marks at the face of the Child Protection Medical, they were very different, again, from those incidents. Turning to the injury to Jay's arm, so that is the burn injury, as it is referred to, the abrasion scrape mark. The judge found that occurred as a lack of supervision.
Yes.
It's submitted that Dr. Goddard's view in respect of a burn from a radiator, because that was the case that was put on behalf of the mother, that the child had fallen against the radiator and potentially burned an arm. I believe on behalf of the father it was put it might have been a scraping sort of burn mark from going down a slide. And Dr. Goddard addressed both of those scenarios. And at C39, in terms of whether it could be a friction burn, what Dr. Goddard says is that you'd expect to see a kind of friction with a tailing, so a tailing off of an injury in respect of that. She goes on to say that it would be a painful injury, and she compares it to another injury that's recorded in the school logs, my lord, where Jay is recorded to have scraped skin off his face, and he was really distressed. And she says that this injury, the burn, as we call it, to the forearm, looks of the same degree of painfulness. And she said she'd be surprised if the child didn't cry when they had this injury. And the mother's evidence at all points has been that the child did not cry when he was in her care. I will come on to the inconsistencies in respect of what the mother says when I address you in respect of the broad canvas. And so, as I said previously, whilst I accept that the court does not have to accept the evidence of the medical expert and can reach a different conclusion, looking at the evidence, it's difficult to see how Her Honour Judge Nisa arrived at the conclusion that those 2 marks, that mark and the 2 possible explanations provided, led to a finding of unreasonable lack of supervision as opposed to an inflicted injury. I accept that Dr. Goddard had said that if there had been a plausible explanation, it could have been an accident. But in the absence of that, it was likely to be considered inflicted. And what I say is in that in reaching her conclusions, the judge has not provided any reasoned judgment as to why she chose to depart from the view of Dr. Goddard, what she based her findings on, other than it would appear that the judge finds that the mother in the proceedings was under the influence of drugs on the occasion in question, and therefore didn't, the judge found, hear the child cry. If I move on then, my lord, to ground 3,
Yes.
that the court has erred in its application of the facts, as previously alluded to, the judge did accept and amend her finding in respect of that, and that the judge has amended to find that the appellant used ketamine the weekend of January the 1920.
This ground is all about the drugs, is it?
This ground, well, yes.
Does that now? I assume we're going to be on this ground. We're going to be invited to allow the appeal on the basis of this finding. Is that right?
Yes, yes.
Well, then, do you need to say very much more about it?
Well, the judge has amended her finding to
Yes.
say that she accepts, as I said earlier, some part of what was raised with her in respect of the intervenor's, the appellant's evidence, that the hair strand length wasn't interfered with by the intervenor. However, in terms of that finding, I say it goes further in that the judge erred in her application of facts. And what I say in respect of that is that the judge has based, when she gave her amended judgment, what the judge says it is that taking the appellant's evidence with the evidence or what is put in the expert's report, that it can take 3 to 4 months for the drug to leave a hair strand test after cessation of regular taking, and sometimes up to 6 months. And that was the appellant's evidence when she was questioned about did she or did she not accept those drug results. The judge concluded that on that basis it would suggest that the appellant had used drugs in January. I say that's a misinterpretation of what's actually in the report.
So the finding is now, the judge's amended finding is, have I got this right? The appellant's use of ketamine was higher than she admitted, and for a longer period of time, she used ketamine over the weekend of the 18th, 19th of January.
Yes.
Do you accept that finding or not?
That finding has been accepted, and my understanding is that the judge has amended
Yes.
that.
So you accept that?
Yes, it's accepted that that's the finding the judge made. I don't accept that it's a right finding.
Oh, no, that's what I mean. Do you accept? So you're appealing against that finding?
Yes.
Okay. So what do you say the judge should have found?
My lord, I say that the evidence doesn't point. There isn't the evidence for the judge to have made that finding that the appellant used ketamine for longer than she said she did, but certainly not that the appellant was using ketamine in January. So, my lord, I ask you to turn to paragraph E7. Sorry, to E7, paragraph 6.2.
E7.
E7, paragraph 6.24. My lord, this is the part of the expert report that sets out some clarification in terms of the hair strand test. And what is said here is that when an individual has regularly used the drug, stops and continues to abstain from using the drug, it can take on average 3 to 4 months for a person to return and not detected results. However, in some cases, it can take up to 6 months. And what I say is that the learned judge has misinterpreted that to mean that if there's a positive result, it could be positive for the 6 months previous to that. And I say that's an incorrect interpretation of those results. The appellant's hair strand test was positive for the end of February to the end of March, and then decreasing amounts from March to April and April to May. So some 4 to 8 weeks after the appellant says she stopped using ketamine, and the subsequent reduction, and it's indicated that there's a large reduction when it's initially stopped, and thereafter a smaller reduction until you get to a negative. And what they say here is a large decrease, approximately 85% would be expected after the first month. Of course, we don't have before February. Once an individual stops using, followed by smaller decreases until a not detected result is obtained. And of course, the appellant's drug results are at E5 and are recorded from the end of February to the end of March as being 0.84.
Yes, it's different E's. It's 2 E's.
Yes, there's some repagination there from
It's the lower page. It's the lower page. Yes. Sorry.
And at the top we can see the end of February to the end of March is 0.84. What we don't have is from the end of January to the end of February. And of course it's in that period of February that the intervenor, the appellant, says that she was using ketamine on a regular basis at that point, and her evidence was every other day. And then she stopped once she was aware that she could have the children returned to her care. And what I say, if we look then above, there's a significant drop from the end of March to the end of April to 0.63, another drop to 0.37, before by the end of May we are barely over the cut-off reporting. And so I say that those results support what the appellant had said her consumption was, but they certainly don't indicate that the appellant was using ketamine in January at the relevant time that these injuries occur. And I say that there is nothing in the evidence for the judge to reach that conclusion. In terms of the other evidence that was available to the court in respect of ketamine, the judge referred to in her judgment that there were extensive historic incidents or recordings of the appellant using ketamine. And as set out in my skeleton argument, that's not accepted as being factually correct. There is one incident in 2019 that's reported more than once, which is disputed by the appellant as to what was said to whom in respect of that. And in the amended judgment, Her Honour Judge Anissa accepts that it's a disputed fact, that the appellant did not have the opportunity to challenge that, and that she should place limited weight on it. In terms of the father's suggestion that the appellant was under the influence of ketamine when he dropped Jay back, again, the judge accepts that he didn't intend to give evidence. His evidence could not be challenged. And she says in her amended judgment that whilst it's a consideration, she hasn't placed particular weight on that. The only other references, other than from the mother in the proceedings, were from two of the mother's friends who spoke to a social worker of R, as it were at the time, and gave indications that the appellant was a regular ketamine user. The social worker that gave evidence confirmed that she got the impression that the two other mothers that were providing the information to her had got this information from the mother and had not had any first-hand.
The mother, meaning the mother.
The mother, the proper mother in the proceedings, and had not had any first-hand knowledge of the appellant taking drugs. The learned judge, in her judgment, accepted that whilst this was hearsay evidence, which was admissible, she was placing limited weight on it, given that the two witnesses.
But the judge relied on the totality of the evidence when assessing this issue, including the evidence given by your client.
My lord, what I say is that she relied on evidence. I say she must have to have reached the conclusion that she did. Evidence that she herself said she should place little weight on and should be cautious.
But she also relied on what your client said, which she didn't accept. Leave aside ground one for the moment. Assume that if the purposes of this argument were against you on ground one, wasn't it open to the judge to take into account her view of your client's evidence as part? Indeed, she was obliged to do that as part of the totality of the evidence. And wasn't it therefore open to her to come to the finding, the amended finding, she's now provided?
Well, my lord, I would say no, that it's not, on the basis that in considering the appellant's evidence, one must look at what she said. She was very candid about drug use in February when her children were not with her. She gave extensive, I would say, information about taking ketamine every other day. She did not need to do that. She could simply have said, yes, I took some on one or two occasions, but she didn't. But she is clear that she didn't take it once she knew that the children were going to be returned to her care. So again, it brings me back to the judge providing herself with a Lucas direction in terms of the appellant having lied about her use initially, and then applying it, I say, to the appellant's evidence in respect of what her use was. And I say there is no evidence base that was before the judge, no reliable evidence base before the judge for her to have concluded that the appellant was lying about her level of drug use at that time, and certainly nothing to suggest that she was using in January. The court had the benefit of some CCTV footage, which, whilst it was obtained for the purpose of identifying whether there were any marks to Jay's face, unfortunately it cut off at 3:45 instead of 4 o'clock as suggested by the appellant. And so although the appellant and Jay were seen in the shop together, Jay's face was not seen. However, the mother was. She appeared to. The appellant was. She appeared to be fully in control of her faculties. She wasn't falling over the place. She did not appear on video to be intoxicated, and it certainly wasn't put to her by any party that she had the appearance of being under the influence of any drugs in that video. We also have extensive text messages between the appellant and the mother, which again is indicative that the appellant was in a sound mind. She was able to compose those text messages. They're fluent. She exchanges multiple ones with the mother, both prior to dropping Jay to her and then afterwards, and they continue on into the evening, as they do the Sunday before Jay is dropped back to the appellant. There is multiple text messages between the appellant and the mother, all indicative of a coherent appellant. And therefore I say, on the evidence before the court, the judge was wrong to make that finding. The evidence didn't support it, and I say that she shouldn't have gone that far. I'm going to move on, my lord, to ground 4.
Yes.
That the court has fallen into speculation. This ground somewhat overlaps with all that has been said previously. So I'm not going to repeat the submissions that I've made in respects of grounds 2 and 3 here. But in terms of the slap to the face that was put down to the appellant on the basis that she failed to report at the earliest opportunity, what I say there, as I said previously, is that the appellant has been consistent in what she says in respect of that. At A2, she says she saw marks and didn't know what to do. When she dropped at school, she says she saw another mother and she asked her what she thought, and she told her to call the social, and she went home, called social, and thereafter...
What words, I think you've got to show what words you rely on in your support of your submission that the judge was speculating.
Well, I say it has to be speculative because in itself a delay or a failure to report is not indicative that a person...
Well, there's a difference between speculation and a legitimate inference. And the judge here drew an inference, didn't she? She wasn't speculating.
My lord, I say she was speculating because the evidence doesn't support that. There is nothing, I say, on the evidence to support that this appellant has caused that injury, and saying that it's because there was a delay in reporting it, or that she didn't text the mother or ask her.
But if there'd been a 24-hour delay, say, and the judge concluded from that, inferred from that the mother, there was a reason why the mother had not reported it. You know, a longer delay. You wouldn't say. Would you say that was speculation as opposed to a legitimate inference?
Well, no, not at that stage, my lord, because a long delay such as that does raise the question of why is there the delay in terms of this short delay. And I'm just going to come on to say that whilst the appellant didn't recall it and it only came out in her evidence, is that it's when she was asked about a telephone number and who had she called at 9:40 in her oral evidence. And when she came back into court, the appellant identified that as her family support worker. So she'd called a family support worker at 9:40. She'd called the local authority. She didn't tell the school first. She told the school after the local authority. And some criticism was made of her for not telling the school first. I say on her behalf that it's not.
Well, can I suggest that in fact maybe I'm wrong here, but this ground is not that she was speculating, but that she drew the wrong inference. You're saying she shouldn't have drawn the inference from the 40-minute delay that the mother was trying to hide something.
My lord, I would accept that. I would accept that. I would accept that. I have termed it speculation, but I am happy to accept.
Well, the judge does use the word "one wonders why." That's
Yes.
the phrase she
Yes.
uses, which stands out. But
and she uses that on a couple of occasions in her judgment. One wonders why, in respect of the injuries and the person that she saw. So I've termed it speculation, but my submission is that she shouldn't have drawn those conclusions, or I'm happy to term it that.
What factors do you say she should have taken into account, but she didn't take into account when drawing that inference?
Well, now, my lord, of course, I would say
leaving aside ground one,
that it was a short period of time. It was a very short period of time. On the appellant's evidence, the child came home in the evening and was distressed. And that is also borne out by what the father said in his evidence. He said that when Jay saw the mother, he started screaming and crying. He says the child didn't want to leave him, whereas the appellant says as soon as the child saw her, he started crying and wanted to come to her, that his face was bright red. All parties accept that Jay had a bright red face. That is accepted by all parties. And in terms of that red face and the mother not noticing it when he came home, what Dr. Goddard said in respect of that is that it's at C61, there are reports of people thinking he had a red face. The redness of that area would have been more, on one side, and I think an observant parent in a reasonable light would have noticed that there was a difference. The appellant, in her answers to questions from Miss Stone, says that she didn't notice the mark on his face because he was cuddled up to her. It's at C230. When asked in re-examination how he was cuddled up, the appellant described that the right side of his face as being upwards to her and him being cradled in her arm. At C306, in answers to questions from the children's guardian, the appellant says that the lights in my flat are quite dull, so my lighting is not bright, and that's at C305. And so my submission is that in all the circumstances as set out, the fact that the mother didn't notice the bruising isn't indicative that she caused the injury.
The appellant.
Delay.
The appellant.
Yes, I'm sorry, the appellant didn't cause the injury, and that the delay in the appellant reporting it was such a short delay that the mother in her evidence accepts that she made a poor choice. And I submit on her behalf that that's absolutely right. She made a poor choice, but that is not indicative of her having caused the injury. And I say that the learned judge went too far in finding that she did on the basis of that short delay. The first contact with anyone in social services we know now is at 9:40 to a family support worker. The mother's evidence, the appellant's evidence was she wanted to give the mother the opportunity to tell her what had happened before she did anything, and she'd waited to see her outside of her other child's school, but she didn't turn up. And there is a later telephone call where the appellant says the mother was incoherent on the phone, and it's after that she telephoned to children's services and the school. And I say on that basis, the judge has fallen, I say, into speculation that she's gone further than she should, drawing the inferences she has, and that the finding that is made by Her Honour Judge Nisa that the appellant caused the slap mark, it is one that she was not open for her to make on the evidence.
Right. Does that complete ground 4?
That does.
So we're on to ground 5.
Ground 5.
This overlaps again with things you've said already, doesn't it?
It does. I don't intend to repeat them, other than to say that in the judge's reasoning as to why one injury, and I accept that there is an error in the skeleton argument, as pointed out by Miss Stone, where it refers to the injury being inflicted by the mother. It is the injury. It should read the injury occurred in the care of the mother and or the father. But in terms of reaching those conclusions, my submission is the judge's reasoning is very confused in this matter. On the one hand, she says that the appellant should have noticed the slap marks, the injuries to Jay's face when he came home.
Okay, you're going to have to help me with paragraph 60 of your skeleton. Does that need to be amended in terms of
it does,
who
yes.
is who?
Yes, so that line should read...
Who is M?
Sorry, I beg your pardon?
Who is M? Do you mean the mother? Or should that be the appellant?
That should be that should be the appellant.
So that should be, in both times where it says M, capital M, is that right? That should be A.
Yes.
And where you say mother in line 4, that should be the appellant.
Yes, it should.
And you name the mother in paragraph 60,
Yes.
and that is the mother.
That is the mother, yes.
And by inflicted,
That
it was
caused in the care.
Caused in the care of.
Yes, it's referred to correctly earlier
Yes.
in the skeleton argument, but it is incorrect there, as rightly pointed out by Ms Stone. I don't appeal or seek to appeal findings made in respect of the mother. I
No.
draw the court's attention to the judge's reasoning in that she puts the mark by the side of the ear down to the mother on the basis that she didn't raise an issue with the appellant when Jay came into her care.
Yeah. Forgive me about I'm still confused about. In paragraph 60, line 2, is the first M mother or appellant?
That's appellant.
Okay. So all
So
M's are both
both
M's.
M's are appellant.
All right. Carry on.
Yes. So, well, as I was saying, the judge attributed the mark on the side of the face, the burn mark, as it suggested, to occurring in the care of either the mother or the father, on the basis that this was a mother who loved this little boy, and had he come into her care with a mark, one, she would have seen it, but she would also have raised it with the appellant. The judge used the same reasoning, it would seem, that because the appellant hadn't noticed the marks on the side of the face, that she was responsible for the slap mark, although the judge does reference that the appellant also didn't see the burn mark. So looking at and I can be no clearer than that, I'm afraid, my lord, because the judgment is no clearer than that as to how the judge came to determine that one injury was caused in the care of the mother and or father, and that the other one occurred in the care of the appellant. And for those reasons, I say that that ground is made out, and I would seek that the court find that there wasn't any basis in the evidence for those findings. And in support of that, I would wish to address you in respect of the discrepancies and inconsistencies. There are numerous ones. I don't intend to go through all of them in terms of the parents' evidence and what is said in relation to that. So, when the mother is asked, and some of these discrepancies don't relate specifically to the injury, although they are in the evidence, but they go to the broad canvas of what the evidence was before the court in terms of the findings that were made. It was suggested to the appellant that she'd enrolled Jay on a Makaton course in an effort to get him to say injuries had happened in the mother and father's care, and that goes to the judge's finding that the appellant did all that she could to set the parents, if you like, in the frame of that. However, there is reference in the paper, and I have to come back with the reference for you, my lord, in that the school report notes that in January, 20th of January, that the mother and the child were enrolled on a Makaton course. So I say that enrolment on the course far preceded any attempts, as it were, for any blame to be diverted away from the appellant, as at that stage there was no proceedings and she wasn't interviewed by the police and not considered a suspect. In terms of the mother, what she says at H26 in her police interview is that she had Jay since he was 6 months old. She'd had him overnight, and at H27 she said it had been every weekend, and she repeats that at H56. And my lord, we know that is not true. After extensive questioning on behalf of the local authority, the mother accepted that that was an untruth that she had told, and she couldn't explain why she had said that. She was asked whether she'd communicated with the appellant that weekend, and what she says at H49 is that she texted the appellant, but she never got a response. And we know from the extensive text messages within the bundle that it is also not true. In interview, the officer specifically asked the mother if she'd told the appellant about what marks that that Jay had on him, and what she says is, "I told her about the ones I knew about." And of course, this contradicts what the mother said in her evidence and what she said to other professionals, in that she didn't tell the mother or the appellant, or raise it with her with the mark that the mother says was there when she collected Jay. The mother in her interview says that Jay had a mark to his face. She refers to it being a burn, and she gives an example to the judge that it could have happened accidentally by running into a cigarette, which in my submission is an unusual reason to put forward. She said that she didn't ask the appellant about it, as the appellant was off her face at H31. She says that. My Lord, I've already addressed you in respect of...
Now, what precisely do these points go to? These are arguments. You're now saying that the judge should not have accepted the mother's account.
I'm saying when looking at the broad canvas of all the evidence that was available to the learned judge, it's submitted on behalf of the local authority and supported by the mother, that it was open to the judge, that the evidence was there for her to make, and she had a discretion to make all the findings that she did. And I say that the broad canvas doesn't support that. And that's why I am referring to the...
I mean, these points go beyond what you put in your skeleton, don't they? You've not... This is a slightly different tack, isn't it? Underground 5.
No, it's not identified or itemised in my skeleton argument, but I say it's relative. And at the time that the skeleton argument was prepared on behalf of the appellant, we didn't have the benefit of the transcripts. It was drafted sometime back in July, and unfortunately not in October or November. So it may go slightly outside, but I say it goes to the same point. There is a reference made in my skeleton, and it's towards the end of it, where I say,
Paragraph 68.
yes, that the judge, having heard the mother's evidence and having found her to be a confused and inconsistent witness, failed to give a proper evaluation of the wider canvas and examination of the surrounding circumstances. And it's that I say that these inconsistencies go to, because they're not minor inconsistencies, my Lord. There is no part, I say, of the mother or the father's evidence that is consistent. I say that there is no part of their evidence that supports the finding that the learned judge made, that the injury to the face, the slap injury, occurred in the care of the appellant. And I say that there is much evidence to suggest that this injury occurred as the result of the child being caught in a verbal altercation whilst in the care of the mother and or the father. In particular, I refer to the text messages from the mother sent just after 1 o'clock in the morning to her friend, saying that the father had hit her, followed swiftly by a message to the appellant saying that Josh had just gone to bed, and that that Jay had just gone to bed, and that Jay didn't like the father.
Right. Now, you've been going for nearly 2 hours.
I'm nearly
break,
there.
And you're coming to ground 6, it seems to me, are you?
I'm trying. I'm mindful.
We're leading round to
I
ground 6.
I have seen the indication of the time, and I'm trying to roll it all into one now.
Yes. So ground 6.
Yes.
Are we there?
I'm in the middle of ground 6.
Okay. So now we're talking
Rounding them all
about
together.
failing to give proper consideration to the father's failure to give evidence.
Yes.
And you cite Mr. Justice Johnson and his dicta about the inference to be drawn. That's been to some extent modified by subsequent decisions, hasn't it?
It has, yes, my lord. But what I say in respect of that is that this was a father who didn't engage fully in the proceedings, I say. He didn't engage in the hair strand testing till very late in the day. Now, I'm sure I'll be corrected if I'm wrong, but that was, I understand, in December. His statement to the court, again, came in very late in the day, and is then, in light of that, a father who attends some of the hearing, but then attends no more, plays no further part in it, despite being invited, despite knowing, despite the best efforts of his instructing solicitor, knowing the importance, knowing what the findings or what findings are being sought on behalf of the local authority. I say that the inference should properly have been drawn that this is such a case where the father's failure to engage, to come to court, to give his evidence, to allow his evidence to be tested is such that the court should have drawn an adverse inference, that he was responsible for the injuries to Joshua. And in support of that, my lord, where I was going before we moved on to that, is that we have the text messages, and it is my final...
And the violent, the evidence of a violent incident.
Yes, and we also have the mother recording, both in her police interview and in her oral evidence, that if Josh is, if she tries to leave Jay in R's room to sleep overnight, he screams his head off. And in answers to questions on behalf of the appellant, when the mother was asked, is that what happened on this occasion, that he was screaming his head off? The answer is yes. So I say with that, with the knowledge that there was a violent incident between the mother and father at a time that we know that that Jay was up in the middle of the night, and that he had been screaming his head off, I say that the judge could properly have drawn the inference and should...
Could, but the judge had this, I'm sorry, the judge had this in mind, didn't she? She knew about this. She refers to this.
The judge
Could
finds
not good enough, Miss Kelly. You've got to show that the judge should.
I say
and was
she
wrong
should
not
have.
to.
I say she should have, and that she was wrong not to. I say the evidence, my lord, is there. I say that is the finding that she should have made, and that if she couldn't identify which of the parents was responsible for that, those slap marks, those injuries, then the judge should have made a pool finding in respect of the parents. And for all of those reasons, my lord, finally, I say that the appellant's appeal should be allowed.
And if the appeal is allowed, what course do you invite us to take?
If the court's with me and allows the appellant's appeal, then my primary position on behalf of the appellant, as her wish, is that the findings made against the appellant are set aside. I understand that the local authority wouldn't oppose a pool finding. The appellant would also not oppose a pool finding. It's not what she seeks, but she wouldn't oppose a pool finding if the court were with me and allowed the appeal to proceed.
Well, just a moment. Your case is that your client the judge should have exonerated your client, should have excluded your client from the pool.
It is, and my primary position is that those findings should be set aside, and that if the local authority wish to pursue them, they can properly do so in the proceedings in respect of Jay. I understand that...
Well, just a moment. What then happens? So, if the findings are set aside, should there be a rehearing of these findings?
The difficulty, my lord, with that, as I see it, is that I understand from the paperwork filed on behalf of the mother that the proceedings in respect of R have concluded with a final order some time ago.
Yes.
Which has not been appealed. So the court would have to consider the proportionality of reopening closed proceedings to retry an issue in terms of facts.
Well, we could remit and I'm thinking aloud here, I haven't discussed this with my colleagues, but we could remit the matter to a judge, probably be another judge. Judge Rayside is the
Yes.
DFJ, to decide A, whether there should be a rehearing, and if so, the scope of it.
Yes,
In the light of
that-
submissions
yes.
that may be made.
Yes.
That would be...
That's certainly a course that's open to the court. I understand that if the court is with me, that the appellant's appeal should succeed, that the mother would seek a retrial.
Yes.
I understand that from.
And I suppose if there was a rehearing, they could be rolled together, the same fact-finding hearing. Well, there are probably different facts also which they rely on in the case of in the proceedings.
Well, those
regarding
facts are
Joe.
relied on as part of threshold in the proceedings in respect of Jay, which is why I say on behalf of the appellant, it is important that the court, very important, that those findings are safe and appropriate, and findings that are made upon the evidence because of the impact they have.
Could the proceedings be heard together? Both sets of proceedings. If we allowed the appeal and remitted the matter for a rehearing, could there be one fact-finding hearing involving both families? That's quite unwieldy. But there is obviously a great overlap between the two cases on the facts. Do you want to think about that and let me know what you say in reply?
Yes.
Okay, all right.
I would like
Perhaps
to
talk about it with Ms Stone. It would be good to have a common position on that.
Less I can assist any further.
Kelly, can I just ask you about points that aren't under appeal in the schedule? Because having listened to what you've just got to say now, specifically number 9, which is that appellant and mother, so it was found lied to do what each could do to implicate the other. As I've understood your submissions, you're really saying that that's not fair. I mean, that really goes to underpins the judge's conclusion that it was your client who was trying to implicate mother, and that's why she lied about the slap to the face. I mean, that's the point. But so what about number 9? That must, I mean, it can't stand, can it, on your submissions? And I don't understand how that's not under challenge. And you could say a little bit the same about 7 and 8 as well, I think. 6, 7,
Just
and
look
8.
at 7 and 8.
So 6 is this is
Framing.
Supervision, but as I understand it, you've just said your ground 6 is that the arm burn there's nothing to do with lack of supervision. This is Jay getting caught in the crossfire in a fight between 2 warring parents.
It is, but I don't seek to appeal that on behalf of the appellant. Likewise with ground 7, the remaining injuries, so the small bruises and scratches. Yes, in light of Dr. Goddard's evidence, I don't think that there is a proper challenge to be made in respect of that finding. I accept what is said in respect of. I'm just finding the.
So 8. I mean, you accept that there are inconsistent accounts.
Yes, that there are.
You say there are
minor inconsistencies. I say on behalf of the appellant, but there are some inconsistencies. But again, I say that is a reflection of her cognitive difficulties and her understanding.
What about 9? That the intervening appellant has lied to implicate the mother. That's what it says.
And mother too.
Yes, the other way around. But
But your concern,
Yes.
What's your appeal?
On reflection and in light of my submissions, I would seek permission to amend the grounds to include that finding as being one that is.
It's not the grounds you need.
Well, it's the finding.
You invite us to set aside.
That finding as well.
But really, your point is that if we're with you on the appeal, and particularly on ground 1, the whole of the process is tainted, and there should be a rehearing. That's your principal argument, isn't it?
Indeed, or if not a rehearing.
Or at least the matter remitted to determine.
Yes.
They should be, the findings should be set aside.
Yes, that is my primary position.
And the matter remitted to the judge, to another judge, to decide whether there should be a rehearing, and if so, the scope of it.
Indeed, my lord. Can I assist any further?
Anything else?
Just one thing, if I may. Coming back to ground 1, who typically will make the assessment that there's a need for an intermediary? Who will ask for the assessment to be made?
It can be either the instructed solicitor who would normally have more contact with the client, but equally counsel can raise that, and then in discussion between both come to a decision as to whether or not a cognitive assessment. Usually it's the instructed solicitor, but counsel can raise it as an issue.
And in this case, it was the same solicitor throughout?
It was, yes, my lord.
My concern is only this, that if we now say, well, with the benefit of hindsight, we'd quite like to have had an assessment, why isn't that going to happen every time somebody gives evidence that the judge hasn't liked?
I don't think it's just a case of the appellant giving evidence that's not the judge hasn't liked. I think in this case, issues became apparent later on because the appellant was an intervenor. She dropped out of those proceedings immediately after the fact-finding hearing. The hearing took place in the midst of the global pandemic. Everything was remote. We had some issues with connectivity. Neither myself nor my instructing solicitor met the appellant in person.
You did not? I was going to ask that. You
I met for the first time
Your
today.
solicitor hadn't met her in person?
And my solicitor still has not. As far as I understand, I have met for the first time today. So hindered by that lack of face-to-face contact. But also, and in addition to that, I said it wasn't until later when going through findings, evidence in respect of the proceedings for Jay that it became more apparent that there was an issue or appeared to be an issue in understanding. It was known and it is accepted that it was known that the appellant said she suffered from dyslexia, and you'll have seen in the psychological report that Dr. Joslin suggests that a further assessment of that might be indicated. And for that reason, in any event, care is taken with giving advice and taking instructions. And so on a go slow basis with somebody who has dyslexia, there is even less opportunity, I say, to identify a cognitive assessment when you are an intervenor and not, as it were, someone who is engaged in the day-to-day proceedings and evaluations of the social work team.
Yeah.
Thank you.
I'm grateful.
Thank you very much, Ms. Kelly. Ms. Kelly, unless you would like another break, I would propose we continue to 1 o'clock now. We start Miss Stone.
Yes.
Is that all right?
Yes, thank you.
Okay. Yes, Miss Stone.
My lord, I'm grateful. Perhaps if I can start with the proposed amended ground
Yes.
one.
So what is your position now on that?
In respect of that ground, the local authority does not oppose permission to amend the grounds, but does oppose permission being granted to appeal on the basis it has no real prospect of success. And even if permission is granted, the local authority says that the appeal should not succeed. So if my lord is content, I propose to deal with both of those aspects together.
Roll up those on
Indeed.
put your argument
Yes.
together.
First of all, a number of matters have been raised that I just would like to deal with shortly, which were not raised in my learned friend's skeleton argument. First of all, the difficulties in technology and the account this court should take of those. It's clear there were difficulties. People were dropping in and out. There's one point, in fact, where I said, and it's at, my lord doesn't need to look at it, but it's C272, when the appellant couldn't hear a question, I said, well, of course she must be able to hear a question. We've got to make sure this is fair.
Yeah.
So I say those don't apply. In terms of speed and different treatment that the judge gave, it suggested to the appellant and the mother.
Take your time, etc.
Proceedings.
The point about
Take your time.
passage
Exactly.
we were taken to.
Exactly.
Yes.
I say that that wasn't unreasonable and doesn't undermine the judge's approach when one looks at what had previously happened in this case. And my lord knows from the transcript that initially, and this goes back to my lord's point as to where was everybody, when the mother started giving her evidence, she was in the courtroom with the judge and her counsel. Mother. At one point during my cross-examination, she asked for a break, went outside,
That's right.
and then left the court
Didn't come
building.
back. Yeah.
And then came back, carried on a bit longer. Then she said she felt unwell, and her counsel confirmed to the court that she was unwell.
That's right.
Because she
Yes.
witnessed it. Then we went off. There were directions for medical evidence that never appeared.
Materialised.
We listed it for directions to try and get it back on track. And then once it did get on track, Mother didn't appear for the first day. So there was a whole background to Mother then re-engaging in the process and giving her evidence to Her Honour Judge Nisa. And when she gave her evidence again, she was at home. The judge was still in court, but Mother was at home. She was clearly upset at points during her evidence, and the court can see, and I can perhaps provide references after lunch if my lord wants to see them, but where she clearly gets upset, and the judge is trying to calm her down. So, and also she was on her own, at home giving evidence. She clearly had some difficulties. My lord knows the findings that are made are about her own drug use and her admitted drug use.
Yes.
She clearly had some vulnerabilities. And I say that the perceived different treatment must be seen in the context of the whole hearing, and I say it doesn't undermine
But that
the
doesn't.
judge's approach.
Does that help you on the appeal? Because what Miss Kelly is saying is that her client should have been afforded the same degree of consideration. It could be said that the mother's problems were more, or the difficulties she was having with giving evidence were more apparent for the reasons
There were.
you've identified, and that whereas the appellants weren't apparent and weren't realised. That's Miss Kelly's
Well,
case.
they certainly weren't realised for the reasons that my lord knows, but I say, in fact, when one looks at the transcript, and if my lord will allow me, I can take the court to a number of examples where it's clear she understood fully what was happening, and clearly the crux of this appeal on the basis of the intermediary and the appellant's unknown vulnerabilities, the crux of what this court, in my respectful submission, has to decide is, was there unfairness? And I say there wasn't.
Yeah.
So albeit there had, if we turn the clock back and said, let's have an intermediary assessment, and there had been the recommendation for an intermediary, she probably would have had an intermediary. It's very unlikely I, on behalf of the local authority or anybody, would say, no, you're not having one.
Well, there'd have been a ground rules hearing.
There would have
There would have been a series of measures debated.
There would.
You would have tailored your questioning in a different way.
Potentially, but I say...
Well, you'd have tailored your questioning in the knowledge,
in the knowledge,
which
sir.
you didn't have before.
Yes.
And there might have been an intermediate. There probably would have been an intermediate.
There probably would have
with
been an
and breaks.
Yes. But I say that there were breaks at times. In fact, sometimes enforced breaks, because of the delights of CVP that we then had.
Yes.
We did have some breaks. And I say, for the reasons I'll come on to, there is no unfairness because it's clear from the appellant's evidence, I say, that she understood what she was being asked and she was able to give her evidence. And also, and my lord knows well, what Lady Justice King said in Rien, that it's not I'm paraphrasing, it's not inevitable.
No,
that
it all depends on the circumstances.
Of course. And obviously in the circumstances in Rien, in fact it was Her Honour Judge Rayside who identified that there were
So it
problems
was.
but carried on. It's perhaps ironic that we're now talking about
Yes.
Her Honour Judge Rayside in another context. So in that case, problems identified but then carried on in a way that was found to be unsatisfactory. On the facts of that case, that particular appellant's IQ and the circumstances very different to this case, and my lords, has only got 2 paragraphs. And the only reason that, on behalf of the local authority, I have seen the full reports is not because I'm instructed in the continuation of the J proceedings, but because obviously it's the same local authority. But if my lord wanted to see further parts of that report, then the appellant's instructions would have to be taken, because as I understand from Miss Kelly, she's only agreed to that 1 paragraph. And also Dr. Taylor's answer saying he did not consider special measures were required was in direct response to a question that's been redacted, includes, does she need an intervenor? So that was the position as at June. He also, and because I didn't have a redacted copy, I only had the full copy, but I was careful in what I said in my skeleton argument, he specifically recommended that best practice should do, so that he went through, as my lord will have seen, many of these reports, made some recommendations, but best practice. the appellant then goes to see Dr. Jostling, who says may need an intermediary for important assessment, an intermediary or an advocate, in that sense of the advocate as opposed to
Yes.
court advocate, for important meetings, assessments and so on. So I say it was quite different. Of course, then we then get the community court assessment that we're told the difficulties and the recommendation of an intermediary. But I say it's, for those reasons and others, it's not on all fours with Re-M or Re-N. So what I say in respect of the process is fundamentally I say it was fair. My Lord may have seen both in the response statement that I prepared on behalf of the local authority back in August and my skeleton, I raised the point that my lady has specifically just raised, no appeal against 8 and 9,
No.
which made no sense. And it made no sense in August, I say, and it's only just now that that is suggested, but that is part of it. But I do say...
I think for my part, the question you perhaps got to focus on is this. The judge clearly attached a lot of importance in her evaluation to the impression that the appellant gave her in the witness box.
Yes.
And her deflecting
Yes.
answers. Does not the fact that we weren't aware of her difficulties undermine that analysis? And given the importance that the judge attached to that, isn't that a strong argument in favour of allowing the appeal? That seems to me to be probably the main point against you.
It's an argument. I don't suggest it's a strong one for a number of reasons. And can I perhaps, my Lord, answer it by taking, my Lord, to certain examples in the appellant's evidence where I say she clearly could follow and understand. So, my Lord, first of all, and I don't know whether my Lord just wants paper references or...
Well, why don't you give an example and then give us the rest? Would this be all right? Give us the rest of, and we'll have a look perhaps over the shorter German.
Of course.
Would that be a good idea? Let's give. Is that convenient? No.
So, I can just have a moment.
Have you got the page references to hand?
I have got the page references to hand, but I just need the email that was sent by the court. So, the summary that the court has from community court is...
In that email that came last night?
Yes, my Lord has it, I don't need to read it out. But in terms of processing sentences, understanding terminology, understanding and responding, understanding complex vocabulary, simple processing verbal information, and remembering key dates, and often gets the details confused. So it's in that context I make these submissions about the transcript. So first of all, I say it's clear that the appellant knew exactly when her son had stayed previously in injuries he'd sustained. That's C197.
Her son knew. She knew.
She knew the dates when Jay had previously stayed with the parents, and I'm talking about obviously mother and father. So her recollection of the history, I say, was clear.
Right.
She gave a detailed account of what had happened in January. She clearly wasn't confused about that. One can see that from C197 to 199. She was able to express a clear view about what had happened and gave reasons for her beliefs. That's C201 to 202. She was given time to read passages, and my Lord may recall the point at the transcript that Miss Kelly took the court to, where I asked, and I apologise because I hadn't checked, she was happy to read, and she said, yes, I am happy to read. And it might be worth actually looking at this particular passage of the evidence, my Lord. So it's C203.
And she was reading electronically, was she?
My recollection is fairly good of this. I think she had a paper bundle and electronically, but she clearly, I suggest, and the transcript shows, she didn't have a problem navigating the papers. I don't know whether Miss Kelly can help, but in any event, she had a full bundle in front of her.
Miss Kelly?
It's a paper bundle.
There was a paper bundle. Okay.
That's
Well,
what-
bundles, presumably. Well, maybe it was only one bundle at that
bundles.
stage.
I think it was bundles.
Bundles. Yes. Okay.
But in any event, perhaps I can go to see
203.
203. Yes, my Lord. It's electronic 339.
Yep.
Where one can see where I said, and it's where I said, sorry, I should have asked you, are you happy reading it? And she said, I'm a bit slow. And then she said, I've read it. And then I said, what do you say has been twisted? And she said, I said all the way through I knew where Jay was. I knew what flat he was in. I couldn't remember the door number. Said all the way through, I've just kept writing it down. Now that part came immediately after the section that the appellant was being asked about. So she was able not only to read what she was being asked about, but she read on and then could put her point of view. And in fact, in the additional supplementary bundle, and this is at A2 of that bundle,
There's a police log.
yes, about halfway down the page, my lord will see a redacted older boy and then a redaction. So it's that part I'm looking at. She asked her friend to have Jay. Does my lord have that?
Yes.
And then, so she was being asked about that, and the appellant read on the section where it says after that, the friend lives along the road, does not know her surname or the house number where she lives, has not been in her flat. So I say that shows that the appellant was certainly following, because she wasn't actually being asked about that bit, but she read on and said, actually, I don't agree with that either. So I say that's a clear example of her understanding and being able to follow the process. Similarly, the appellant clearly was able to ask questions if she didn't understand, and my lord already has the point at 207 that where she asked if an abrasion was in fact a bruise, and I say adaptations were made because I then in fact used the word scratch, which she clearly did understand. The appellant was able to clearly express what she told Dr. Wadey, the doctor who'd carried out the child protection medical just about a year before. So that's C10. She managed to distinguish between usual events in Jay's life and unusual injuries at C214. She remembered where she'd read about certain incidents. That's C216. She was able to argue a case as to why there was no evidence she said she was under the influence at C227. She clearly understood the hair strand analysis because she talked about and clearly had knowledge about the time drugs could remain in a hair sample. That's 228. She, at one point when connection was lost and the counsel who had dropped out was then told what the question had been, the appellant then said what her answer had been. So again, I say clearly following the proceedings, and that was that C232. She used quite complex or sophisticated vocabulary herself. She used the word insinuate at C240 and C264.
Let's have a look. 240. Whereabouts?
My lord's ahead of me. Can I just have a moment?
Top of page, second answer.
Yes.
Okay.
And then on 264, and I say that's clearly in context, and then at 264, same. Yes, you saw that with Miss Stone. You also said you lost your temper with him, did you not? That is why you grabbed him, and that's talking about another child, Jay's another child. And then she says, not the sort of temper you're trying to insinuate. My lord already has the reference, but for ease it's C249, where she said, you're trying to confuse me and it's not working. She used the phrase on C252 towards sort of bottom third of the page. She says, when she's being asked about injuries, and there she was being asked, and in fact was asked in chief about injuries Jay had sustained, and clearly understood the word sustain. When she's asked, when you do not know what has happened, yes, I do not know how it happened, but Jay has a tendency to scratch himself. So again, I say that's not unsophisticated language. And then the last reference I would take my lord to is at C280, when the appellant said at the top of the page, "I'm not having you put words into my mouth." So those are examples, I say, of evidence from the transcript and from the appellant herself that she did understand. And in addition, my lord, her statements filed in this case are extremely detailed. She'd clearly given very detailed instructions to her solicitor. She produced text messages, she produced photographs, and gave a very clear timeline of events in not just one but two statements. So I say that, firstly, there's no unfairness demonstrated. Secondly, the judge was entitled to assess her evidence. I'm not minimising, of course, the importance of an intermediary, but, and I say that with that in mind, just because a litigant has an intermediary does not mean a judge cannot find they are not being truthful. And I say that the judge was entitled to form those.
Well, the point is not. The point is that the question is: was the judge entitled to draw the conclusion she did, bearing in mind that the appellant had unrecognised difficulties?
But I say she was entitled to, because of her assessment, as she was bound to make that assessment of her credibility as a whole, taking into account the totality of her evidence and all of the evidence.
Thank you.
And my lord, in terms of...
well, would that be a good place to stop, or are you making a final point?
That's probably a good place to stop.
Okay. Do you want us to look at anything over the short adjournment? You've raced through a number of references already. Perhaps that's what you were going to give us.
I was going to give the court a number of references in terms of deflection, where I say she was
Which
entitled
bundle are they in?
To core bundle.
Okay. Should we do that? Or should we do it over lunch? Should we do it after lunch? Okay. I think on reflection we'll deal with those at 2 o'clock in court. I don't think there's any danger of us not finishing, is there?
I don't.
No. Okay. We'll do that.
I'm sure my lord will move me on when my lord's heard enough.
Okay. Right. Now, just a moment. Two o'clock.